And because of that, we are moving from an animated hand to a robotic one.
Oh, she's on the stage.
I'm sorry, sir, are you lost?
Sorry, I'm looking for Dr. Torres.
Yes. Hi.
Great. You've been sued.
Most medical dramas portray legal action as a stressful, devastating event, much like in this clip from Grey's Anatomy. While this may be true for some cases, the reality of the matter tells a different story. The Canadian Institute for Health Information reported in 2024 to 25, 1 in 17 individuals experience at least one harmful event during acute hospital stays from the care they receive. Though this is the case, in Canada, legal action against doctors can be an uphill battle for patients. In 2024, it was reported that 1,021 decisions were made on medical legal cases. Only 9 of those decisions were in favor of the plaintiff, with over 600 being abandoned or dismissed. Looking at specific fields, other reports showed that in cases against ophthalmologists, only 44% ruled in favor of the plaintiff. When against plastic surgeons, patients won only 32% of the time, and only 25% went up against psychiatrists. These statistics are similar across all specialties, where rulings usually side with the defendant physicians. This fact dissuades individuals from taking action against doctors when they've been hurt or affected in some manner, resulting in many viable cases never seeing any resolution. Not only do low win rates restrict individuals from filing lawsuits, but the cost of continuing litigation can be astronomical. Typically, individuals pay anywhere from $50,000 to $200,000 out of pocket for trial fees, lawyers, and other expenses. Though there is litigation insurance, many insurers don't take many clients who are pursuing legal action against malpractice. Making things even more daunting, this burden is really only felt by the patients themselves, not the physicians. While their salaries may not be enough to cover the exceeding costs, almost all Canadian physicians are aided by an organization called the Canadian Medical Protective Association. The CMPA is a non-profit company that provides medical legal advice and defense for Canadian physicians. Boasting a vast amount of assets, the organization presents a massive barrier to patients seeking compensation. In 2024, the CMPA spent $132 million on legal action concerning civil cases for member physicians, while spending another $107 million on other legal matters. What makes things even worse is the fact that most of this funding comes directly from taxpayer dollars. Physicians must pay a fee to use CMPA services. However, these fees are largely subsidized by provincial governments, reimbursing physicians using taxpayer dollars. This means patients are not only paying directly for their own litigation, but indirectly for that of the physician. With the resources it has, the CMPA can also mount an aggressive defense against patients, as they have no incentive to move quickly or settle cases. The current system is set up to dissuade individuals from seeking legal action against physicians. If they do, they face prolonged litigation, exorbitant costs, and the Goliath, the CMPA. It is clear that a reform within the Canadian legal and healthcare system must happen to properly serve affected individuals. Some sources suggest a no-fault scheme in which patients do not need litigation to receive compensation, while others propose strict hospital liability, putting the responsibility on the hospitals rather than the physicians themselves. Though the answer is yet to be determined, the fact of the matter is that our current system and institutions obstruct patients, making it difficult for them to receive help for issues caused by healthcare. As once written by the lawyer and philosopher Cicero, Salus populi suprema lex. The health of the people is the supreme law. The system must change, lest it continue to fail those it serves and break the highest of laws.